This presentation discusses a foundational law case, the Pennsylvania Association for Retarded Citizens, known as PARC, versus the Commonwealth of Pennsylvania. Only a few decades ago, children with intellectual disabilities did not have the right to a public education. In fact, Pennsylvania law allowed public schools to deny services to children who have not attained a mental age of 5 years by the start of first grade. This case was filed in 1971, and it was the first right to education lawsuit in America. The goal was to overturn a Pennsylvania discriminatory law that prevented children with intellectual disabilities from attending public school. In 1972, a consent decree ordered access to a free public education and training appropriate to any child's learning capacities. It became the basis for the Education for All Handicapped Children Act in 1975. It was also followed by a lawsuit against the School District of Philadelphia to enforce the act. So let's start at the beginning. In January of 1971, PARC files their complaint. All plaintiffs, which were 5 families, and all, quote, retarded children, which is the terminology that they used at that time, and note that there were more than 53,000 children with intellectual disabilities in the state of Pennsylvania, have been refused by the defendants the right to free access to public education because they are retarded. The children named in the suit are school age. They would benefit from education. They want to be in school, and they have been wrongfully denied. These were some of the claims in the complaint that was filed. And your defendants are the Secretary of Education in Pennsylvania, the State Board of Education, and the Secretary of Public Welfare, and all school districts in Pennsylvania for their role in supporting the law that denies education to such citizens because they are uneducable and untrainable. Beginning on page 24 of the complaint, the counts charges are listed and refer to Pennsylvania law that specifically denies an education to people with disabilities. In some, they are 1, uneducable children, 2, violation of the 14th Amendment, 3, mental age of 5 years at a minimum, 4, exceptions to compulsory attendance, 5, on compulsory school age, 6, defendants applied those discriminatory codes to these children. So those are the charges that were listed. The complaint asked the courts to right these wrongs and even to provide compensatory years of education to each retarded person who was excluded. The predominant question of the case, quote, the capacity of all retarded children, whatever their attributed intelligence, to benefit from education is the predominant question of fact in this action and is common to all members for this class. And this is in light of the Pennsylvania laws since 1864 that provided for a free public education for all children over the age of 6. The complaint goes on to address each of the 13 children specifically named in the suit, and the heading for each section is the non-education of so-and-so. As the complaint says, no child may reasonably be expected to succeed in life if he is denied the opportunity of an education, which is a right that must be made available to all on equal terms. In fact, among every 30 retarded persons, again to use the language of the complaint, out of every 30, 29 of them, if education is provided to them, are capable of moving toward self-sufficiency. The complaint also states that, quote, education is even more important to the development of the retarded citizen than it is to the normal citizen, for the latter may develop skills willy-nilly and informally, but the retarded citizen cannot without sustained educational attention, end quote. 9 months after the filing, which was January 1971, a consent agreement and order occurred, which was basically an agreement by the Commonwealth of Pennsylvania. They consented specifically not to apply the various public school codes that denied the education of the plaintiffs. It was a cease and desist order, to provide immediate relief to the plaintiffs, and to find all children that would fall under this clause or this law, this order. Remedy the laws, including providing due process hearings within 15 to 30 days, and using the term exceptional children. The order that the amended stipulations and consent agreement be approved was adopted on May 5th. Now that is because there were 13 school districts that filed objections to the October 1971 order. 12 eventually dropped, and thus the amended consent agreement or order and injunction was signed May 5th, 1972. Also, I wanted to mention that this was kind of the first idea similar to the child find of IDEA, but back then it was called Compile, which was specific to Pennsylvania and this lawsuit. And the obligation was to locate every child in that classification that needed to be placed in a free public program of education and training appropriate to his or her capacity. So after that was signed, we had the passage of the Education for All Handicapped Children Act in 1975. And then later, and this was reauthorized in 1990 to IDEA. Okay, but then something else happened in the Commonwealth of Pennsylvania. PARC sued Philadelphia. The school district, PARC claimed, failed to provide multidisciplinary team evaluations for the vast majority of mentally retarded children, also failed to hire and to train persons to provide such evaluations, and failed to establish a procedure for providing such evaluations. So in summary, the district denied mentally retarded children, their language again, their rights to due process of law, to a free and appropriate program of public education, and to receive that education in the least restrictive educational setting possible. The plaintiffs asked for special reliefs in line with the laws, including the maintenance and implementation of an individualized education program, an IEP. This is key because this lawsuit demonstrates that no school district is exempt from following the new laws. It shows that PARC, in its watchdog capacity, meant to continue to protect the interests of all children with intellectual disabilities. Further notable failures in the school district of Philadelphia were a misuse of the homebound instruction remedy, inappropriate assignment to such instruction with failure to follow up every 3 months, and failure to give parents notice of evaluation and their notice to the right of hearing. So there were a lot of breaches of law in their behavior. 11 affidavits were filed with this complaint. So it was going to go to trial in June of 1981, and there was a trial brief created by the attorneys of the petitioners, PARC, and it stated that the petitioners will prove at trial the allegations which amount to a deprivation of rights of the petitioners to an education granted by the decree. It also states that since entry of the PARC orders, these obligations have been supplemented by the requirements enacted by Congress in the Education for All Handicapped Children Act of 1975 and the Rehabilitation Act of 1973. And as the petitioners will demonstrate, respondents have not complied with the essential requirement of the PARC decree, nor with the parallel provisions of the intervening federal statutes. The brief is explicit in its demands of the Philadelphia School District to meet all of the Commonwealth obligations. Other case law is quoted to establish precedents. They did reach a settlement agreement. Started out in July of 1982. And actually you had an intervener, the Philadelphia Federation of Teachers, I guess ended up representing the Philadelphia School District. And so it was ordered by the United States District Court for the Eastern District of Pennsylvania on July 20th, 1982. Some of the obligations included in the settlement agreement included 10 hours of in-service training for all school personnel that draws upon, quote, the experience, skills, and insights of, and to be conducted by, local as well as national people engaged in the education of severely handicapped students who possess demonstrated state-of-the-art knowledge and skills in training teachers and other personnel in necessary skills and competencies, as well as the continuing training of parents in the areas of development of IEPs, management and teaching activities and routines, and development of active parent groups. Wow. They want top dog people to come in and do this training, and they're supporting parents and families. This settlement agreement also stipulates the district's obligation to provide all related services by qualified professionals, including but not limited to occupational therapy, physical therapy, speech therapy, including signing. Funding and budgeting is also outlined in this document. From the PARC case and these two samplings of current cases, it makes me wonder why schools are so underfunded that they cannot provide the most basic services to our families and students. What can we do as teachers to promote equity in our neighborhoods, schools, and communities? Looking at these two current cases, or fairly current cases, the first one, it asks, does Pennsylvania's current system of funding schools violate the state's constitution and deprive students in low-wealth communities of the quality public education they need and deserve? We also have this other class action lawsuit filed on behalf of Asian language-speaking students and their parents who sought to ensure individuals with LEP received appropriate translation and interpretation services within the school district of Philadelphia. More than 25 years after that original lawsuit was filed, and after numerous legal agreements, the district continues to fail to provide appropriate services. What was the impact on education of the PARC case? Well, two main findings of this landmark case are the right of students with mental retardation, again, their language, to receive free public education, and also, as long as possible, include this kind of students in a regular classroom rather than an isolated special class. But the impact goes further. PARC versus the Commonwealth of PA set the precedence and was followed by federal legislation that offered similar, if not more detailed, protections against discriminatory practices in American schools, including the formulation of IDEA in 1990. The PARC case was considered a foundational case in the realm of equitable education for students with disabilities. What other cases or lawsuits were spurred by the settlement of this one? Well, Mills versus Board of Education, 1972, a class action lawsuit filed against the District of Columbia, expanded the impact of the PARC case with a court ruling that said no child could be denied a public education because of, quote, mental, behavioral, physical, or emotional handicaps or deficiencies, end quote, and that the defendant's, quote, failure to provide such an education could not be excused by the claim of insufficient funds, end quote. In the 2.5 years following the PARC and the Mills decisions, 46 right to education cases were filed on behalf of children with disabilities in 28 states. Most of this presentation came from the primary documents, and all of these primary documents can actually be found at the Public Interest Law Center. And that's just pubintlaw.org, and you can search that out if you want.